We are here for the webinar that is of a very good importance, very serious importance. And our presenter, Oleg Korolov, is here. So I'm going to start with admitting him and introducing him. Hello, Alan.
Hey, Oleg.
How are you today?
Doing good, doing good.
Thank you very much for doing this. We are already recording, if this is okay with you, because an attorney is probably the last person that I want to do something without having a consent from. So, do you?
That is true, and attorneys, we don't usually like to, but you know, let's go ahead and do that. I think we're getting into some really cool stuff today. So yeah, please do.
Love it, love it, love it. Yeah, I actually agree with you as far as some good stuff. I think it's probably one of the underrated topics because once this topic comes up through the escrow procedure. So when somebody's purchasing the property, this is one of the questions that I would get asked from people when they get documents from escrow, right? And it's just one page Western form, right? Where it would just allow people to put the check mark on whether or not they want to own it as a community property, joint tenants, or what have you. And they would randomly ask me, hey, how should we respond to this? And all of the time I would have to tell them, well, legally I cannot advise you on this because I'm not an attorney. And unfortunately, most of the time that would be it, right? So people would just go ahead and Google something. Maybe the escrow company would be a little bit more open to providing them advice on this. But unfortunately, there's a very, very big implications to being wrong with the check mark that you could put. And it could be a very, very expensive wrong check mark that you could use. So that's why I think even though this topic is not glorified, it's not something that people gonna, just fill up the room with and try to push each other away from the room just because there's no space. But it is very, very important topic. So I'm very thankful for you to do this. But prior to us getting into this, can you tell us a little bit more about you, about your firm? How did you end up working within this field of law in particular?
Sure. In practice for about 17 years, our firm is Vaksman Khalfin. We are based in the Bay Area, but we do serve clients in the Los Angeles area and also in the San Diego area. Our firm was born as a trust and estates firm. So that's where the firm started, even before I joined the firm. And we still are today a full service trusts and estates firm. That means we help people setting up basic trusts, basic estate planning. For others, that might be more advanced planning if they are higher net worth individuals and have some different type of goals. Or it's sadly when loved ones pass and administration of their estates needs to occur. And so I spend most of my time in those areas. I born and raised in the San Francisco Bay Area. I still live in the San Francisco Bay Area. I got into this area a little bit sort of interestingly. Prior to trust and estates, I spent the first few years of my career doing corporate work and business law, and it just wasn't as fulfilling for me. I wasn't really feeling like I was helping people dealing with business operators and sort of these business transactions and such.
Right.
And so I wanted to work directly with the people that and so that I hopped in estate planning. My partner Robert Vaksman was an estate planner before me, and through estate planning, we've just been able to help a lot more people. As I said, we've done this for almost 17 years. We've helped thousands and thousands of people with estate planning. I've answered this question: how should I take title into my house or property? Thousands of times. It is the number one most common question. So that's kind of how I got here. The firm, as I said, we're in the Bay Area. We're a firm of 13 people. We have a lot of great team members. And so part of what we do is to, help people get this estate planning done. Not just start it and stop it, but actually cross the finish line.
Yeah. Let me ask you this before we actually get into the weeds about different forms of holding title to real estate here in the state of California. How often do you actually get a phone call from people saying, hey, we're in the middle of transaction, we're in escrow, we need to do this, as opposed to people have already concluded the transaction owning real estate and maybe trying to secure that the property is not gonna end up in a probate court if one of the people that own it would die.
Yeah, we often every day. That
Yeah.
in California, what really brings people to me and my team is real estate. When you buy real estate, that's when you start thinking about this type of stuff. So yes, all the time. Frankly, I get that call from my clients who I've served, and for those
Yeah.
folks, because they already have a trust, I can give them a nice, easy answer, and I can help them out
Yeah.
real quick. However, if you're a new client and calling us for the first time, and you're in the middle of escrow, I'm probably going to tell you, well, why don't you just close escrow? Let's not screw that up. Let's not complicate that at all. And then when you're done with escrow, we can work with you and we can move the title to a trust. So I don't really like to jam it in before escrow, but yes, that is very common. And sometimes why that happens is because of this form that you were referring to in the beginning. That one-page form from the title company that looks so simple and looks just so like, oh, no big deal. But boy, is that a big deal,
isn't it? It's kind of deceiving, isn't it? Because when when this page pops up, you got to understand the logistics of a transaction where now the person needs to still provide all of the paperwork to the lender, whatever the documents that the lender requires. Now the buyer also is probably going through the inspection period, so they're getting all of this stuff from the inspectors, from the seller, all of the mandatory disclosures. So they're just getting stuff from all over the place, and they just go, which one of it I don't have to look at, and they kind of make this determination for themselves. And it seems like, look, it's because it's the part of escrow instructions being just a reflection of the purchase contract, which they already know. So they feel like, screw it, I just need to provide this basic information. I can put NA on the insurance side because it's not decided yet, and they kind of skip over this. And I think it is very, very underrated issue, because just as you said, it could cost people lots and lots of trouble afterwards. But let's actually get to this part. So what are the most common ways of holding title in general in the state of California? And I think the beautiful thing about talking to you is that even though you're in Northern California, the state functions the same, Northern and Southern California. So especially with your side of business, that's not like talking to, for example, somebody that works with tenants' rights, because that could be very, very municipality specific. With the thing that you're working with, it's a state specific thing. So the fact that you're in San Francisco does not really mean that you would be out of touch with how things are here in Los Angeles, just so people understand that. But coming back to my question, what are the most common ways of holding title to the real estate?
Well, I'd like to answer that a little differently. Instead of giving you the ways that you could hold title, I will give you the way you should not hold title first. There's one way. Do not, under any circumstance, hold title in your name, right? If your name's Joe Smith, it might be Joe Smith, an unmarried man, or Joe and Jane Smith, a married couple's community property. That's just wrong, and I'll explain why in a second. The way that title should be held is in a revocable living trust. That is by far revocable.
Okay.
We can get into different types of trusts and all that later on, but generally, revocable trusts are the easy ones, the common ones. 99% of trusts are revocable. They don't affect your mortgage. They don't affect anything. There's no separation between you and your revocable trust. So the way to hold title for a primary residence, for investment properties, for a property by your kid or what have you, is not in your name. It's in a living trust. That is the short of it, and that is the best way to hold in California in most cases. Here's why. If you hold title in your name and you pass away, let's just assume that you're a single individual and you have some kids. You hold title in your name and you pass away. Before your kids are able to take title to your house and to inherit your house, if the title is in your name, a court process has to happen. That court process is called probate. And you may have heard of it. It has a bit of a bad reputation in California, and rightfully so. Probate is a long court process, can take nearly 2 years. LA County can take a little bit longer because LA County is a little more backed up than others. And worse than it taking 2 years and requiring your children to go through this really brutal court process, but the worst thing is that it costs an arm and a leg. The cost of probate is determined by state law. Us attorneys don't make it up. There's a statute, there's a part of the probate code that says how much attorneys get paid for probate.
Really?
And it's, yes, and it's based on the value of the property. And it's not based on the equity in the property, it's based on the gross value.
So it doesn't matter if you own it outright, it doesn't matter if it's leverage to the ears.
Correct.
Matters not.
Correct. And here's how it works. For the total gross value of the property, the first 100 grand is taxed at 4%. The next 100 grand is at 3%. From then on, it's 2%, and it scales down from there. Just to give you an idea, you know, you got $1 million condo that goes through probate. You're looking at, you know, $23,000 in probate fees, $25,000 in probate fees.
That's a substantial amount.
That's a substantial amount. Imagine you're talking about a larger home, you know, a $2 million home, right? So it's just a crazy thing because it can totally be avoided. The only reason that happens is if somebody passes away and the property's in their name. That's it. So that's the big thing here is unless you want to, you know, torture your family when you're gone and make them pay a lot more money, you need to avoid probate. And that is, in my view, the number one most important goal with how you hold title. That's where you should be thinking. So that's a long-winded answer to your short question. Yeah, well, so there's one other form that I recommend, and obviously we're being very general, right? There are going to be cases where it may make sense to do irrevocable trusts or all these other fancy structures, but most people in California don't need that. Most people in California need basic estate planning, and that's a living trust, right? Now, there's one other type of scenario where my answer might differ. And that depends on, you know, your appetite for these things, right? So for your primary residence, always a living trust, you can stop the conversation right there. But if you own an investment or rental property and you have tenants, there's a lot more risk attached to a situation like that. And sure, you'll get insurance, but insurance is contractual and doesn't always pay out. So if you own rental properties, then the recommendation changes a little bit. For that type of situation, I would recommend a limited liability company or LLC that holds the title, not a living trust. And the reason for that is to insulate any exposure, any liabilities, any damages that might be caused for the rental, to insulate that money, that exposure from your personal assets. So that if there is a situation with the rental and your insurance doesn't cover for some reason and there's a judgment for, you know, $500,000, if the title's in an LLC and you're operating the LLC correctly, then the exposure can stop at the LLC level, meaning they can only go after the assets of the LLC, which is just the one property. So that is a slightly different strategy for rentals. But other than that, always living trust.
Question on the LLCs. Obviously, the lender has the right to have the due on sale clause with the change of ownership, which LLC will trigger. 99.9% of the time, that probably will not be the case. So that will probably not happen. But the lender does technically have the right to call the loan due if you change the ownership. So if you change it from Oleg Korolov to Oleg Korolov LLC, the lender does have the right to say, well, we actually gave the loan to Oleg Korolov, not Oleg Korolov LLC. So how do you go about that? And what is the real exposure over here? Is there any real risk and how to mitigate it? Because I mean, obviously, we're trying to find the best solutions that will protect people to the best of their abilities, and having this exposure to possibly having their loan called due, especially for people that carry very, very low APR loans,
Mm-hmm.
that's a great risk. So how do you go about it? How can you minimize the risk by transferring property from the personal name to the LLC?
Yeah, that's a great point, and certainly in today's climate, nobody wants to lose their interest rate and to be rated in any way. There is no way to ensure that, right? You're absolutely right. A deed of trust that secures your loan will say in it, right in the middle, you can't transfer to another entity. Well, certainly an
Right.
LLC is another entity. That's why there's protection that it gives you. So the recommendation is to speak with your lender and to get that authorization. Some lenders do provide it, some more easily than others.
Hmm.
Most have a process. Even Chase, which is not the easiest to work with, does allow it after a little bit of back and forth. You need to have a dialogue with your lender. You certainly should not be pulling the trigger on an LLC transfer without that, because they could exercise that due on sale. Now, they rarely do. It doesn't happen very often, but certainly nobody likes to get a letter from the lender saying, hey, by the way, your loan's due in 30 days. Thank you very much. Now, I have had clients that haven't asked their lender. They may have gotten some kind of letter and then they just transferred it back. Okay, that works too.
Oh,
Um,
okay.
Now, there is some nuance here, because if it's a Fannie Mac loan, they do have to require, in certain cases, an LLC transfer, and they can't do the due on sale for Fannie Mac loan. So there's some nuance there. But yes, you should be
Hmm.
aware. Folks should be aware of that potential for an LLC transfer for sure. And you'd also want to, in today's, property insurance climate in California, now, and I didn't say this before, this is a new recommendation from our office, is if you're thinking about putting a rental in LLC, maybe give your insurance broker a call and chat with him and her about property insurance, because you're certainly going to want to add the LLC as an additional insured to that policy. And I don't know if
Hmm.
that allows them to keep
Changes the policy as well, huh?
property insurance, right? So you just never know. But the LLCs for rentals, that's definitely more of a higher goal, a more advanced goal. I just, I want to reel it back in. I think for most people, you have to just understand that title needs to go in a living trust. Like, that is really going to be the foundational piece. Even for a rental, if an LLC is
Hmm.
just a little bit too much to deal with and you just don't really want to bother with that complexity, you know, I wouldn't say, okay, and then push you too much. But if somebody tells me, Alan, living trust is too complicated. I don't need one. I'm going to challenge you on that, because that's simply not the right choice. Um, and we do see it. We do a lot of probate work all over the state, and
Yeah.
people have houses in their names, and it's just a very, very sad thing to watch the family have to then pay a ton of money to get the house.
Oh no, 100%. But I think the main point here is that you guys actually can get involved in this process when you're strategizing that you know if the LLC or the trust or what have you would be the best way for the specific individual to go.
Yep.
With you guys would be able to actually help them even with this communication with the lending
Yes.
institutions to just make sure that if you do change the ownership from the personal to the entity ownership under LLC, you guys will help people have all of the paper trail, all of the confirmation that the bank or the lending institution is okay with the fact that it's
Absolutely.
being transferred. And I think this is number one point, because a lot of time, people would feel like, well, they're exposing themselves, not when they're aligning themselves with the professionals that would be able to guide them through this process, because it is a process. Just as you said, some lenders could trigger it, some lenders can. Can you create an LLC and transfer the property there through the whole of records? You probably can, but you don't know everything that you need to know in order for this process to happen. So I think that's why it is so helpful to actually talk to people and
Yeah, I
understand the
mean,
strategies and implications that.
yeah, LLCs in specific can be a little tricky as a do-it-yourself project, because there's a couple things going on. Initially, when you form the
Hmm.
LLC and you do all the initial paperwork, that has to be done correctly, all of it, and it has to be done in a way where you can build on it through additional paperwork. Because if your paperwork your operating agreement, all your stuff. If it's not done correctly and somebody sues the LLC, they can essentially get rid of the LLC protection by saying, hey, this thing wasn't formed right. Look at these problems. Look at these errors in how it was formed or how the operating agreement was drafted or whatnot. That would just erase the protection. And I had a client who, didn't have us form the LLC. She had her CPA form it. And it was actually out of state, and it was weird, and it wasn't formed right, and the operating agreement did not read like it should. And so that wouldn't work, right? So you got to be careful initially when you form it. Then you got to be careful when you actually move the title, because the title is going to go from you to the LLC through a recorded deed. A recorded deed is permanent, and it replaces the grant deed that you got when you bought it. So if there's an error on that deed, well, that's a really big problem to fix later on if you're not around. So that's another part of it where you want to be darn sure that that deed is drafted and recorded correctly. And then, of course, there's the dealing with your lender and all that fun stuff. So yeah, it's a little bit more, it's a little more for somebody to try to do on their own. And yeah, certainly we are very happy to help with that in California and also in Nevada.
Good stuff. Good stuff. But let's dial it back a little. When we're talking specifically about, let's just say, residential transactions, when people are involved in it, they're obviously getting the loan in their names. And just as you mentioned, that a lot of the time your recommendation would be to just close the way they find fit and then transfer it into the trust. But while people are still in escrow, most of the time people will not just open their trust right then and there because they're preoccupied with some other things. So what would be your recommendation for people to, as far as holding title, and at least when they close on a property and then later come back to you to re-strategize? What would be the best choice? And unfortunately, one of the reasons why I started actually talking about this particular topic was through the scary situation that I've had with one of my best friends, where holding property in one way rather than the other did save them a little bit, but the person is never going to be back anymore, and the wife, instead of mourning, had to deal with a lot of stuff, and they got lucky with certain things just by the pure luck, by holding things in certain way, but that was just the pure luck for them. And I think it is a very, very important topic. That's why I really wanted to chat with you, because people just underestimate it. Well, you hold the property the way you hold the property. So, and a lot of the time, the life will get in the way, and it's going to take people a little bit of time to get to you. So when they close the deal, what would be your recommendation out of the possible ways of holding title before they get to you and actually form a trust? What would be your recommendation there?
So, I mean, there's not a lot of options, because if you don't have a trust and you don't have an LLC, let's say, and you're looking to take title as an individual, well, if you're not married, that's it, right? It's your name. Yeah. That's all you got. Right? If you're married, then it depends on whether you, and this is a very California specific thing I'm about to say, whether you hold community property assets with your spouse or whether you both have your own separate property. In other words, combine your money or not. Most people in California, it's community property. So my most common answer for a married couple who owns the assets together is a title, husband and wife, as community property with right of survivorship. If you do not hold title as community property, my answer differs, but that is what we most typically recommend as an interstitial vesting for title purposes. And that will give you some tax benefit for community property between the spouses, and set the stage for transferring to the trust after you close.
And how would it differ, community property with the right of survivorship, how would it differ to a joint tenancy with the right of survivorship? What would be the challenges there?
They're similar. So with community property with right of survivorship and joint tenancy with right of survivorship, as the terms indicate, you have right of survivorship. That's really important. What that means is if one of the owners, husband, passes away, it goes to the wife through that right of survivorship. If the two owners are married, they have this ability to do community property with right of survivorship. And with community property survivorship, you get the full step up in tax basis. Meaning, when the property is sold one day, you get the maximum footing and positioning for minimization of capital gains to the extent possible.
Mm-hmm.
With a joint tenancy, you only get half step up.
Mm-hmm.
So you don't get, when the one dies, you get a step up, but for that half, you don't get a second step up when the second dies. For community property, you get a double step up so that the whole property is stepped up to the date of death.
Can you explain the step up a
yeah,
little bit,
yeah, let me back up.
in a little bit more details, if you don't mind?
Yeah, so when you sell a property, let's say you bought the property for $1 million and you sold it for $2 million. That $1 million profit that you made is taxable by the IRS, by the FTB. Capital gains you pay on that margin. Now, the bottom number, the $1 million, what you bought it for, is called your basis. That's your tax basis for the property. A step up, or a step up in basis, means that your acquisition cost, what you bought it for, that number goes up for tax purposes to the value of the property when all title holders die, for cases of community property. Meaning, if you have a deed that's community property of right of survivorship, and it was $1 million when husband and wife bought it, and it's $2 million when they passed away, and their daughter gets it, and the daughter sells it, shortly thereafter, she's not going to pay any capital gains, because when she inherited the property, it was worth $2 million because she got a full step up in basis, and she sold it for $2 million the following month, $0, right? In the joint tenancy scenario, you would have not the full step up. Half, 50% would get a step up to first value at first death, and the second half will get a step up to value second death. So for the second death, you would have a basis that's stepped up, but for the first death, you wouldn't, and there'd be a lot more capital gains to pay on the books. So it's a little bit of a complicated tax thing. However, the message is simply the best way to ensure that you are minimizing this, if you're married and if you hold your assets with your husband or wife, is to do community property with right of survivorship. It gets an added bonus because of the marriage. Now, if you hold the property with your brother or your friend or your cousin or your girlfriend, well, then you can't do community property with right of survivorship. You don't get those tax benefits. You have to do joint tenancy, and that's that. Joint tenancy is still fine in certain cases. If you're not married, it results in the surviving owner receiving the property without probate. But at the same time, with both of these, when the second owner dies, when husband and wife are both dead, if the deed is community property, you still have probate at second death. So yeah, those are the two options if you hold title jointly. Well, there's a third option that we should also talk about if we're going to go down this road. Now, again, these are all options when you hold title with somebody else. Go about title by yourself. Well, your life's easy in theory, and you don't have any decisions to make there. But if you hold title with somebody else, the third option, which is more about if you hold title as a business partner with somebody and they're not your significant other, let's say, is tenancy in common. Tenancy in common, there is no right of survivorship between the owners. So if Jane and Dave own the property 50-50, tenants in common, they each have their own 50% and they can do whatever they want with it. It doesn't go to the other of them when they pass away. And so that's usually when you have, business partners and one wants to give to his family and the other wants to give to her family. You would typically see a tenancy in common. And that could involve trusts and LLCs and all that.
Lovely. Thank you so much for getting a little bit deeper with this, because this is, I think, sort of the first question people would have, and then later on they would come back and have additional consultation and additional actions with you. But as far as logistics of this go, when would you recommend for people to open up the conversation about transferring the property into the trust? How soon would you recommend them to do it? To minimize risk, I would imagine as soon as possible, right after they're done with the process of purchasing the property.
Yeah, even before, ideally, you call me and we talk about this and get this done before you even start looking for a property, because
Hmm.
then it's already there. You can take title in the trust, like it's all very easy. And remember, we're talking about property, which is great. And frankly, most of my clients' wealth in California is real estate, given the situation. But everybody has other assets. We all have bank accounts. We have stock accounts. So this conversation of estate planning would also involve all your other assets. We harp on probate for real estate, but there's the same probate for bank and brokerage and all your other assets.
Hmm.
So we will talk about everything else, and everything will get included. So ideally, it's early before you start looking, and if not, then it's after you close, after the grant deed to close has been recorded, then shortly thereafter you would want to get started. It makes me, having done this for a long time, it makes me to see title in people's names. It's a risky proposition, and despite what you may hear in movies and sort of pop culture, setting up a trust is not difficult. It does not have to be a super hard, complicated, and expensive process. It can be. I mean, we can all complicate things to make them,
Right, right, right.
more crazy. But in general, it doesn't have to be complicated. It can be changed as life goes on. It can be added to. It can be iterated on. So it's not like you need the absolute perfect decisions from day one. No, from day one, you just need to make sure that the assets are in the trust, the titles in the trust, right? So it's
Yeah.
it's actually a pretty easy process now.
Let's get to logistics of this. So let's say I come to you and I tell you, Alan, good to see you today. I just purchased a property. I would like to set up the trust. How does this process look in general? Does it how long does it require? What could be the costs associated with it, and things of that nature? Practically,
Yeah,
how does this look?
the process is fairly straightforward. For most people, it takes about a month.
Hmm.
That, of course, depends on a little bit on the client and how quickly they make decisions. Um, it starts with an intake where we talk to them about their situation, their assets, their goals, and we explain a bit about what this all is, how estate planning works, and what the options are. After that initial intake, I can give them a recommendation. I've done this for a long time.
Right.
Everybody says their situation is simple, and sometimes it is, right. So I can tell you generally what you need in that first call, or maybe in a second call. Um, we'll then give you a quote for the fees. It depends on the situation. It depends on the complexity, the number of properties. If you're higher net worth, there's going to be some other stuff that we would suggest. But the
Mhm.
most sort of basic package: single folks, 3,500; married folks, about 4,300. Includes a property, includes a lot of great stuff. Um, the process, it should be simple, and it usually is, but sometimes we all have that one area where we're sort of like, oh, we're not sure whether it's the guardians for the kids, whether it's the
Right.
guardian for the dog, whether it's which kid gets what, and so we try to get people through those decisions. Um, we do need clients to provide us those decisions, though. So after a client engages with us, we get on another call, we send a questionnaire. We need to gather this information. And
And most
there's
of the
nothing.
time, it's not even you guys holding it up, and or
No,
it's mostly clients just trying to
it's much.
understand and
Yeah,
decide among themselves what to do.
it is. And everybody's different, and everybody, some people are quick decision makers and don't think
Right.
twice, and other people are a little bit slower and want to think a little bit more, and all is fine. And so it just depends on the client. I have clients that after they engage, they get their stuff to us within 30 minutes, and we're off to the races. There are other clients that take a lot longer. Just depends. But we get your information, and by the way, this is not difficult information. This is, it may be difficult to decide what names to provide to me, but
Right.
I'm asking for names, addresses, copies of deeds, perhaps, social security numbers for you. Like, there's not a lot of stuff we're asking for here, right? I don't need your tax returns. I don't need, your family tree. Once we get the information required, it takes us about 2 weeks to draft the initial documents. And from there, we review them with the client. If the client has changes, revisions, what have you, we do those. And if not, we move forward to signing. The documents are signed, they're notarized. If you are local to my office, which, you know, your clients are in Los Angeles, so they're unfortunately not. For our Los Angeles clients, what we do is we send a mobile notary to their house. The mobile notary comes, just like for, you know, for loans. They sign, they scan the documents, they send them back to me. We review them, and then we record the deeds electronically, just like title companies. And then, so about a month is the typical time frame if we're making fairly quick decisions.
Right. And you know, just as a side point for people that are thinking, oh my God, $3,000-4,000, that's a lot of money. I would just say that it is a lot of money. I would agree with this, but it's how much less than going through the probate court just financially. And I understand that this is the decision. You know, we don't want to think about our death. We don't want to think that one day we're just going to cease to exist, that it's a dark thought. You know, people just purchased the house. It's you know, it's the best time in their life, right? They're enjoying it, they're loving it. It's one of those things that the importance of it is just hard to understand until it happens. But I think it is important to get this point across very early on, and I think it's good that people don't have to make this determination throughout the escrow. I think it's very helpful that you mentioned that, you know, it is fine to close the transaction the way you find fit. You know, community property is a right of survivorship. And I understand it all depends on individual cases, but a lot of the time it would be that, or for individual owners, there's not that many options available there anyway.
No.
But I think it's important for people to understand that, yes, you do have to pay a little bit more money right after you just paid a lot of money for the house and all of the services around the transaction, but it's times and times and times more. And I'm not trying to sell your services. I just think they're very important. I personally find that very important. I just think it's under delivered to people, the importance of that, because, you know, this industry is very much glorified. My industry I'm talking about, right? It's all about buy the house. Oh my
sexy
God,
houses.
Yeah. So
I don't have sexy houses to show in my marketing. I guess I
right.
could show coffins.
But it is very important. That's
it's
people
not
don't
a
get
fun
as
topic.
excited about signing things.
No, I mean, if you get excited about estate planning, I mean, you know, it's a little bit weird.
Let's have a coffee, right?
Nevertheless, it's one of these things where traditionally estate planning has always been for the, you know, old, and it's for the rich. That's always been the thing. It's not true. You know, if you think about it, and you know, if any of the people watching or listening, you know, reach out to me, I can send you a chart. There's a wonderful chart, and this is usually the first thing I talk to people about, is I show them the chart of probate fees. I just show it to them, and it literally has, you know, the size of the estate and how much you're going to pay. And then after seeing that, most people understand that, oh, okay, you know, we have a regular home worth $1 million, but does that mean that we want to pay $23,000 for probate, or do we want to pay $4,000 for a trust? Right? It's one of those things. So yeah, education is a big part of what we do, because people don't necessarily understand how this works. You know, my family immigrated from the former Soviet Union in 1979, and you know, that whole community. I grew up in that community, and there was at least this idea where, oh, you die, the assets go to your kids automatically. It's all everything's automatic. It just happens. Well, no, nothing's automatic. I mean, sure, it does happen, but it goes through court. So it's not for the rich anymore. It's for everybody, to ensure that, you know, the money and the assets you worked your butt off during your life don't get squandered, you know, in court costs and attorney's fees. And the other thing is, people would always say, oh, estate planning is for the old, right? Why don't you go set up at a senior home, and I'm sure you'll get lots of business. You know, most of my clients are actually younger these days. For new clients, our sort of two most common scenarios are first-time home buyers who now need a trust all of a sudden, or new parents who just had kids. You know, we spent all this time talking about, you know, probate and how awful it is, and how to make sure that you can transfer as much of your assets as possible. But there's a whole other side to estate planning: guardianship of minor kids, medical decisions. There's all this other stuff that we do. And so, yeah, young parents, that's another source of new clients for us, because all of a sudden now they are responsible for somebody and they have to get their affairs in order. So it's really, while not all that, exciting of an area, it's really important. And I'll tell you what is exciting. Once you finish your estate planning and you get the binder and it's signed and it's notarized
You
and
don't
it's
have
all
to
done,
touch it
yeah, you
for
don't have,
many, many years
yeah,
to
you don't have,
come.
correct. You put it away. You don't have to think about it. It's done. You don't have to, you feel good. And then house, and they give you that one pager of how you want to take title, you confidently tell them, in our
Mhm.
trust, please, and you know that you had gotten all done. It's not to say that you forget about me as your estate planner.
Right.
Once you have a trust, you just need to make sure that you keep, putting assets into it, that you don't start acquiring assets in your name again, even though you have a trust, right? So there's a little bit of education again that has to go into that on our side. But yeah, there's a lot of education going on.
No, absolutely, absolutely. Can we talk about what kinds of trusts exist over there? So you mentioned
Mhm.
revocable and irrevocable, and help me pronouncing it because clearly I'm having trouble with this.
Yeah, it's that's the general split.
Right.
There's a dichotomy at the very top level. There's a
Hmm.
revocable trust and there's an irrevocable trust. A revocable trust is the most common type of trust. And the reason
Hmm.
for that is because when you form it, you are still in charge of it. It's for your benefit. You can change it. You can get rid of it. You can revoke it. I mean, you can do whatever you want. And most interestingly is that it continues to be attached to your social security number for tax purposes. Therefore,
Hmm.
it doesn't affect your mortgage, it doesn't affect anything. It's all very easy.
So a
So,
revocable trust, just to clarify, if you move the asset from Oleg Korolov to Oleg Korolov Trust, whatever the name that is revocable trust that's associated with me, that will not trigger due and sell clause
correct,
because
correct.
okay,
Yeah,
but
and
that's a
there's a
very
federal
important
law that
distinction.
there's a federal law that actually restricts the due on sale clause in that setting. So lenders cannot exercise it. Most trusts, 99% of trusts are going to be revocable. That
Hmm.
is by far the most common trust because, husband and wife, they can keep the property, they can keep the assets under their control, under their name, everything remains as is, no new tax filings. And then when they
Hmm.
pass away, then it goes to the kids, the trust becomes irrevocable, everything kicks into gear, and probate is avoided. So that is by far the most common type of trust that people do. There is another type of trust, an irrevocable trust.
Hmm.
As it sounds, you can't change it once you set it up. In
Hmm.
California, you also cannot set one up for yourself because California doesn't allow an irrevocable trust for your benefit. So irrevocable trusts, revocable trusts are really used for probate avoidance,
Hmm.
incapacity planning. Irrevocable trusts have different goals. Irrevocable trusts are used to remove assets from your estate if you're a high net worth. And that's really more, we don't want to get into too much of that today because it doesn't apply to most. But
Hmm.
if you are in a potentially an estate tax situation, if your estate's anywhere 15, 20 million or north of that, you may be looking at irrevocable trusts to get assets out of your estate and into its own legal identity for tax planning. Or if you're in a very high risk situation, you're high risk profession, and you want asset protection, you may consider an irrevocable trust for asset protection. I will say this: irrevocable trusts and real estate don't really play nice. If you have a loan on the real estate, no
Hmm.
lender will ever authorize an irrevocable trust. We talked about LLCs and due on sale clauses. Yeah, that's maybe fine. At irrevocable trust, lenders will immediately exercise the due on sale. They don't like those. Um, so really, real estate and irrevocables aren't all that common. Certainly, pulling out equity later, getting a line of credit is going to be impossible. You won't have the flexibility. When folks do irrevocable trusts, they're oftentimes using cash, stocks, things of that nature, and they're often setting aside for their children. And really, it's just to boil it down, irrevocable trusts are for more of estate tax plan, higher net worth situations, not for most of us. You got to be careful though. There are some attorneys out there that push these seminars where they go out there and they tell folks, hey, you need irrevocable trust for asset protection. What if you're sued? What if you're this? What if you're that? And they give people these crazy ideas. And then they call me and I kind of have to unwind that whole idea. So, irrevocable trust sounds sexy. They just, oh, we're going to protect you from everything. True, but they're going to have way bigger problems than that when you're actually into one. So for this call, I think people generally should not be thinking about irrevocables. If you have no estate planning, if you do not have a revocable trust, that's where you go first. Your estate planner, whether it's me or somebody else, would be happy to talk to you about irrevocables, how they interplay with revocables, how they coexist, how that all works. But otherwise, if you just have one trust, it's going to be revocable.
It sounds like more of a complex idea for somebody that might need a little bit more sophistication within their real estate or overall estate planning needs. It just sounds like one of those instruments among, I'm pretty sure, many other ones that you would use. But it's a little bit more of a sophisticated play, which would not apply to majority of people. And you actually mentioned a couple of numbers, and I think it's important for people to understand that with the trust, they're probably not going to be sort of the minimum amount of net worth that they would need in order to even start thinking about it, simply because in a respect of our conversation today, we're connecting it not just to the decision making with incapability, for example, or some other things, but we're connecting it to real estate. And real estate in most cases would come with a substantial amount of down payment here in California. So even if you think I don't have a lot of money in my bank, you're still putting some money down for the real estate, and this is your net worth that you do need to protect. So would you say that there's sort of a minimum threshold that people start thinking about the trust, or if we're connecting it to real estate, it would still be a good idea to just go ahead and open up a trust right away when you have a chance to do so?
Yeah, that's correct. I don't, there's no dollar amount that makes it required to do a trust. There used to be, back when properties in California were worth not a lot. Today, any property in California is going to be worth more than the threshold that the court. So there is a threshold. The court does have a number, right? If the property, it's such a low number, I forgot what it is, $60,000.
I think it was $60,000.
It's
But
some absurdly low number. So
yeah,
it's silly. It's silly, right? So if you own real estate and it's worth $100,000 or more, let's say, you need a trust. It's not about the value. It's about, in my view, the type of asset. Does the asset that you're buying, does it have a right of survivorship built in automatically? The answer is no. And therefore you need a trust so that asset that you're buying can go to your loved ones without problems. Simple as that, right? It's just a matter of making sure that can happen. But yeah, there's no threshold for dollar amounts. It's really, the way I tell folks is this: if you have real estate, you need a trust. If you have minor children, you need a trust. If you have a business, a small business, your own business, you need a trust. Those scenarios without a trust, transfer of assets when you're gone, is very complicated and expensive in those three categories. So that's to me the main categories of folks that need trust.
That makes sense. Yeah, no, I think this is a great idea for people to start getting educated on this, and even if they're not gonna end up getting the trust right away when they're in the process of purchasing real estate, for the peace of mind, it's definitely something that needs to be in place. And I think you're doing a great job educating people, because I know you're holding certain seminars. You guys are putting out some content as it pertains to just educating people, because knowledge is power in this case, and it's one of those not glorified topics and not glorified avenues that we need to be involved in, that really will benefit if people had a little bit deeper understanding of. Because you're right, it's not just for, the rich folks, which are over 75 or 80 years old, that are, on the way out. It's for everyone. And unfortunately, I do have a personal experience here with very, very near and dear to my heart people that are not with us anymore. It is unfortunately not just for somebody who is of an age. It's for everyone. And, the life happens to all of us, so it is crucial. It is impossible to overestimate the importance of being protected and making sure that not just you, but your family and people around you have this extra level of protection, which is needed. Because just as you mentioned, it is a very, very complex procedure. Just imagining that somebody would lose a loved one and have to go through the procedure of reclaiming rights to the ownership of certain properties for the next 2.5 years. In California is just notorious, especially Southern California, Los
Is
Angeles,
the
for the time
worst.
frames.
The worst. We have the most expensive probate in the whole country by far. And LA County, probate costs the same in every county in California. LA County just happens to be the slowest one. I mean, it's just, it's LA County. It's the largest county in the state, right? So I find myself in LA about once a month at the courthouse there. It's definitely a good experience always.
Yeah.
I think that covers
No,
it.
I really appreciate that. I really appreciate that, man. If people want to find you, and I'm probably gonna end up finishing the report and then posting this in a couple of days or so on a YouTube, so we would be able to share this with people that are interested in the topic. I think it is important for people to understand that when attorneys say it depends without answering the question, it actually means that they really need to look into your particular case. So my suggestion to people would be not trying to Google this kind of stuff, not trying to understand how to form trust and wills and all of this stuff. But talk to professionals and make sure that things are set up properly. And I'll make sure to put your information down below. But if somebody would be watching this, what would be the best way for people to reach out to you and your partners to make sure that they can schedule a consultation and move this process along?
Give us a call, shoot us an email. Our number 877-780-4727. That's generally the best way. We have, a 13-person team. Somebody's always going to pick up the phone. They'll be able to talk to you and they'll be able to, get you scheduled with the appropriate person. We serve clients in California, we serve clients in Nevada and New York. And so it just depends on where you're at. Different attorney would handle it. I personally am the managing partner of our California office, for example. Also email us. Firm is Vaksman Khalfin. I probably won't bother spelling it on right now, but there will be perhaps like a thank you slide at the end of this that has the info. But give us a call.
No.
We love talking to folks on the phone. We don't hide behind computers. We want to get to know you. We want to talk about your situation, and we can tell you pretty quickly if we can help, how we can help, how much it will cost. As somebody who had actually done estate planning before I became an estate planner, my initial takeaway from that experience was that it was overly complicated. I just was confused through the whole process. I was confused, and I was a lawyer already. I was just confused. And that's sort of a style of some attorneys to confuse and to just go really
To
deep on
justify
all these.
the price or why?
I think that's wrong for a few reasons, but in my view, the number one reason is that prevents people from finishing the process because they're just so doggone confused. Or if they do finish it, they don't understand what they did. To me, that's a fail. I want to get you finish line. I want to get your estate planning buttoned up and done extremely well, but I also want to make sure that you understand what we did and that you are understanding it the whole way through the process. So we know how to get out of the weeds in certain areas. There are certain areas where I'm not going to send you down a rabbit hole because I know that it will cause anguish for you and you as decision making. So
Right.
we're going to get you across the finish line, and that's really something that I try to make sure is that we make the process easy, we get people through it, we don't complicate where we don't have to.
No, I really appreciate your time, and more importantly, I really appreciate your approach, because I think managing clients' expectations and just making sure that people understand what's about to happen, what's to come, and not trying to, play your occupation role that took me 7 years to become a lawyer, and now I need to make sure that everybody feels like it's so complicated. I appreciate the fact that you're simplifying it for me as the person that talked to you over the last hour, for people that would watch this, and for people that will come to your office or talk to you over the phone, because I think that's the name of the game. People need to understand what they're doing and don't feel like they're stupid while they're conducting the transaction that they're not doing all the time. I feel the same way about my work, so I really appreciate what you're doing. I think it's very important service that you're providing to people, so thanks a lot for your time today. I'm gonna clock out right now, and I'll make sure that all of the information that about your firm is gonna be down below. We'll post it. We'll be able to share it. But thanks a lot for today, and I'll be looking forward to be recommending you and your firm to my clients, because I really like the approach you guys take to estate planning, making sure that clients' understanding of the process and client success in the long term and the long run is the most important gain over here. So.
That's right. Thank you, Oleg. This was awesome. And thank you, everybody out there. Talk soon.